Yeah, let me make a simple discussion in terms of um, the sugar challenges that we're having in Uganda, but also particularly with a specific focus on Busoga maybe. What does the Ugandan law say about licensing of, say, sugar mills, for example? I know this cuts across our whole country. The Ugandan law, specifically the Sugar Act 2020, Act 13 of 2020, established a statutory framework for licensing sugar mills and jaggery plants. Under the Act, an investor must actually apply to the Uganda Sugar Board, what they call the USB, for a license to establish or even operate a mill or a plant. The application must include prescribed details such as the location of the proposed mill, the board, and once it's duly constituted, it has a legal authority to process and even grant or even refuse licenses. So critically, we are saying that the Act envisions the USB as the central regulatory authority responsible for all aspects of sugar industry regulation, including license insurance. So this replaces the prior practice where the Minister of Trade, Industry and Cooperatives, or even the Investment Authority issued certificates or letters of no objection. So a High Court in Kampala, for example, ruled that this practice contravenes statutory law because they had not been operationalized in accordance with the Act. That's something you must understand. So in legal terms, we are saying that only a valid licensing process is one conducted by a properly instituted USB acting under the Sugar Act. Remember that. Now also, we could argue and say how binding is this as far as maybe the 25 kilometer rule in terms of sugar mill licenses. This becomes a legal requirement or even just a policy guideline. Someone can argue that way. But for starters, we could understand that the 25-kilometer distance rule originates in the National Sugar Policy to 2010. So the policy document that guides orderly development in terms of the sugar industry. So under the policy, the mills should actually not be licensed within a 25-kilometer radius of an existing mill or within the radius of 30, percent of the land. So that's something you must understand. And the provision is a policy, not express statutory wording in the Sugar Act itself. So nonetheless, when interpreted alongside the Act, it informs the regulatory discretion of the USB because the USB is empowered to consider matters of location and sustainability when granting these licenses. I would argue in terms of USMA versus Attorney General and others, which was a 2025 case. The High Court applied the purpose approach and even held that granting licenses in violation of the 25-kilometer policy was contrary to policy and given government intent. So the ruling is very important in terms of that. It effectively elevating the policy guidelines into a legally enforceable standard insofar as is concerned. So although not explicitly a statutory rule in the Act, the 25-kilometer rule has actually acquired legal effect through judicial interpretation in terms of integrating into regulatory framework, as I just argued. Now, if these mills are, for example, licensed within a restricted distance, does that amount, for example, to a violation of the law or simply a regulated discretion, for example? We could argue that the distinction is subtle, but also very important. Why? Because without the constituted USB, then any license granted by, for example, the MTIC or even through letters of no objection is illegal and therefore has no effect as held by the High Court in that particular case. So when the USB, for example, is properly placed, then the 25-kilometer policy creation becomes part of the jury assessment. Okay, the board must consider the policy zoning guidance within the determined area, if you like. So the failure, for example, to consider the policy and license within this prohibited zone would actually be a mere discretionary error. It would be a ground for judicial review based on illegality or irrationality or even procedural impropriety in terms of that. Remember that. Now, also, we could argue in terms of someone could argue and say, therefore, thus the licensing mill within the restricted distance creates an absence of due consideration within the policy. It's not a question of being harmless, but as far as the discretion is concerned, it renders the discretion unlawful and therefore a question of subject to being challenged. Now, one would argue, for example, that do existing millers have a right that must be protected before licensing new competitors nearby? Yes, that is fundamentally true. Both statutory and even constitutional principles support protecting legitimate expectations and established within established investment, as it were. So under administrative law, for example, where an existing investor has actually relied on a regulatory framework that includes spacing or even zoning rules, sudden departures from those norms without fair processes can actually violate the principles of legitimate expectations and even fairness. So existing millers also have contractual relationship without growers and even sustain investments in terms of infrastructure. So they create property and also create interest in terms of the deserving of protection under the statutory law and even the constitution. So we could argue also that the High Court ruling recognizes this indiscriminate insurance of licenses undermined in terms of the viability of the existing operations that lead to instability in terms of cane supply, justifying judicial intervention. So while these new investors are actually free to apply for the licenses, the regulatory regime must protect the sustainability and even economic viability in terms of existing legal operators pursuant to both the law and even public policy. And that is fundamentally important. Also, you could argue that from the constitutional perspective, how should government, for example, balance the rights of investors within the economic rights of these farmers? Yes. So under Ugandan constitution, every person, for example, has a right to practice any unlawful occupation, and the government has mandate to promote economic development and even protect these livelihoods. That is fundamentally important. And in terms of that, we could argue that balancing this right requires substantive guides or of avatars in terms of non-discrimination, in terms of and fairness. Investors, both new and existing, should actually be treated under the clear, predictable, and even consistent applied rules of licensing and even location. Now, also protection of farmers in terms of economic rights. Sugarcane, farmers really rely on mills to market their produce. Yeah, so this excessive creates licensing and fragmentation. Cane supply undermines incomes and even violates these economic interests, as it were. So regulatory clarity and stability becomes fundamentally important in terms of this discussion that we're having today. In terms of another dispensation that you may want to argue for purposes of this discussion, a constitutional balance would actually ensure that licensing does not become a mechanism of privileging certain individuals against others. No, it shouldn't be that case. Yeah, all farmers have an equal right in terms of this particular dispensation in terms of the interpretation that we're having today. Now, if political, for example, pressure influences these licensing decisions, definitely this would undermine the law. And we are saying that political interference results in biases, for example, or in terms of subverting statutory processes, for example, issuance of licenses by the ministry instead of the board, the USB board, as I just argued. So we have to argue that circumventing policy safeguards, for example, ignores these distance requirements, and it creates arbitrary expectations for specific investors, and that is something that you have to be very mindful about. So then it becomes then a question of determining what is rule of law, what requires in terms of government requires to have actionable, lawful, even rational, transparent, and procedural fairness when they are doing these things. So we could also argue that the High Court, for example, in terms of this particular identify these illegal acts in terms of licensing outside statutory authority, demonstrating that the political influence results in unlawful conduct and therefore subject to judicial correction. And that has to be understood again in terms of this dispensation that we're having today. We could also argue that what reforms could actually would someone recommend to prevent future legal conflicts within the sugar sector? I mean, one would argue and say a fully operationalizing USB in terms of Uganda Sugar Board, it becomes a question of debate. It has to be constituted with clear mandates, with adequate funding, with technical capacity, in terms of creating a functionality system here. We have to codify distance in terms of the zoning rules in legislation to incorporate the distance rule and other zoning requirements directly into statutory law, not just policy, to eliminate ambiguity and even judicial disputes. We could also argue in terms of clarifying the licensing criteria and timelines, set out regulations that are clear, measurable in terms of that have economic viability, sustainability, environmental considerations, so that decisions are actually predictable. We could also argue that strengthening dispute regulations in terms of mechanisms rather than in litigating every license dispute, that we could establish administrative review panels and even mediation mechanism within the USB framework. We could also argue in terms of enhancing stakeholder consultation, institutionalizing meaningful consultation within existing villas or farmers or associations and local authorities that help licensing processes to balance these competing interests. It's supernaturally, it's extremely important for you to understand that these are important in terms of creating a subtle or even a formidable sugar industry in terms of our country, Uganda, but particularly in terms of the people of sugar who have an overhead advantage over probably other regions in terms of growing the sugar cane. Thank you very much. Yes.